Good evening and welcome to Undoing I Do with Stephanie and Ade. I'm Stephanie Hunnell, the owner of the Hunnell Law Group in Asbury Park, New Jersey, and your co-host for this evening.
And I am Adelola Sherilyn Dow, the owner of the law offices of Adelola Sherilyn Dow in Staten Island, New York. Happy Thursday, as we usually say.
Happy Thursday. Good to see you.
It's good to see you too. A sight for sore eyes. I feel like I haven't seen you in forever. Meanwhile, that was just last week.
It was just last week.
Woo! I am so excited about the summer, though. I mean, it's really fresh and breezy here. It's not terribly hot today.
Today is beautiful. I went for like a 3-mile walk this morning. It was lovely. It wasn't like
I think I saw pictures of you guys on the beach. Is that what, was that a part of the walk?
Mm-hmm. Yep, we went down to the boardwalk.
I didn't get an invite, but that's okay. I'll forgive that. It was a couple's moment. It's okay, no problem.
Oh, we saw this cute little girl today. She was adorable.
Now, how old was she? Because my first thing is, why wasn't she in school? How old was she?
Oh, she was young. She was probably like 3 or 4 years old.
Okay.
She had a cute little Wonder Woman bathing suit on, and she ran past me, and then she stopped, and she was like, "Did you see how fast I ran?"
She's like, "I really am Wonder Woman."
I was like, "Yes, I did." I go, "I think it's because you have that Wonder Woman bathing suit on." And she's like, "It is."
I love the kids. They are so adorable. So adorable. And that's a great segue because we're going to talk about supporting your kids.
Mm-hmm. Child support. Who's entitled to modify it, what, where, and when? And how.
Because the last time we did a show about child support, it was really about establishment. And this time we're going to talk about how you increase or decrease your child support amounts and obligations. I guess the biggest one is probably emancipation. We could knock that right out of the park very quickly.
Yep, I think that's the biggest. I won't say the easiest because it's not always so straightforward. But yeah, when your child has reached the age of majority, it means something different, I think, in New York and in New Jersey. So there's no bright line rule in New Jersey. In New Jersey, it could be 18 if they don't go on to college. It could be like 24 if they decided to go beyond college.
Yeah, so it's 21 in New York. That's just it. 21 is the emancipation age, unless there are other factors, such as your child has gotten married, your child has joined the military. And by the way, if they get married and then get divorced, that usually doesn't matter unless there's something in your agreement that says that a void or nullified marriage will do away with the emancipation. And so the other thing is full-time work. And pursuant to the IRS code, I believe full-time is 35 hours per week. And so there are some people who deviate from that in their agreements. But generally, if your child is working during spring break or summer break or something like that, or if they're in law school and you're still paying and they have that $10,000 a month stipend position, they're still not emancipated probably.
Yep, true. So true. Mostly, you see cases like that where you just have to maintain health insurance and you're maybe not necessarily paying full freight child support. But in New Jersey, the trigger word is being beyond the sphere of influence of your parents. What that means is that you're supposed to not be able to decide what your child is able to do. Your child is making independent decisions. Your child is basically leading their own life. Except if they're going to college, because for some reason the court doesn't really entertain that as a basis for being beyond the sphere of influence. Even when that child is unwilling to share their grades, unwilling to really have a relationship with the other parent, maybe doing whatever they want, living their life, working part-time jobs, you're still going to be on the hook for child support.
Yeah, absolutely. And so that whole concept of moving beyond the sphere of parental influence is very, very subjective. It's very, very fact sensitive. And so you may think that your situation is one where your child is just wilding out and they're just doing whatever, and you think that you need to be in court, getting them emancipated, and then the court will say, okay, so they smoked a joint. All right, yeah, no, they're not emancipated because they smoked a joint. They're not. They're in college, and perhaps things happen, and so no. But yeah, what we have also in the state of New York is this concept of constructive emancipation, which is when a child, generally over the age of 16, that's not necessarily a bright line rule, but it's generally over the age of 16, just decides that they are not going to have any kind of involvement with their parent, okay? And it has to be that it's through no fault of the parent. So if the parent in prior years abandoned the child or neglected the child emotionally or something like that, then you're probably not going to prevail in your quest for constructive emancipation. But let's say that one parent aligned the child to them, if we're not going to use parental alienation as a term, one parent aligned the child to them and completely made sure that you were cut off as a parent having any kind of input with regard to your child, and iced you completely, you have a better chance of being successful at your constructive emancipation claim.
Yeah, that's interesting. I think in New Jersey, and correct me if I'm wrong, because I don't think we have anything like that here in New Jersey, but that could be a good argument for why you're not paying for college expenses. At least a very large factor in why you might not have to pay college expenses. That doesn't mean that you wouldn't be paying child support. And the court can say, if you're not paying college expenses, then we're going to hold you to a higher level of child support because you're not having that extra expense. So it really, again, it's all very fact sensitive. I have a question about emancipation. So let's say you have two kids, one is emancipated. Does that mean that child support is then just cut in half? So if you had $200 a week for two kids, now you have one that's emancipated. Is that going to be $100 a week?
No, and you may wish that it were, depending upon how much money you're now making. Because what the court will do is they will do what we call a de novo review of your finances, because you have a change of circumstance with one of the children emancipating. And so they're going to look at your numbers all over again. So if you have been in the boat of persons whose exes did not take them back to court for all of these years, and you've just been paying your $200 and you've never gotten an increase, you may be in a situation where you get an increase that's actually over $200, depending upon what you're earning now.
That's the same in New Jersey. They're going to take a look at what the child support is supposed to be based on the circumstances as of the date of emancipation. So if you've had increases in income, increases in rental properties or something, for example, that are generating income, the court's going to consider all of that when determining how much child support is appropriate for the one remaining child. And even if everything remains the same, there are some fluctuations in the child support guidelines and worksheets as far as the child support calculation goes. So you can, again, end up paying more money. Or just only a very small percentage less.
So now the question is, because I'm all about the return on investment, the question is whether that is worth it. And so when people call our offices and they say, oh, it's just a simple child support thing, sometimes I will tell them, as you know, I will say you do not need a lawyer, but I will always say that you should consult with an attorney, even if it costs you $200, $300, $400, whatever it is that the person's going to charge you. Because if you just go in blindly, you may be knocked over your head with some reality that you had not known about. And so at least have someone who does this day in and day out look at your numbers, be truthful now, don't come up with no fudge numbers. Look at your numbers and figure out what your actual obligation would be. Because it's often that I tell people, somebody's making $50,000 5 years ago and now they're making $200. I may just tell you, keep it simple. Just keep paying the money that you're paying right now because you're about to get hosed with this child support amount.
Yep. You and I both do the same thing with strategy sessions. So we'll schedule a strategy session and I will review child support. If I get a post-judgment request to review child support, I review it in advance. even if I don't have all of the details, I kind of run a few guidelines figuring out what the amounts might be. So that way they can make an informed decision about what they can expect. Because I've had cases where they're ready to go and the child support amount goes up. And I always feel better when I'm able to say, look, I showed you these guidelines in advance. Here was your range of what child support can look like. You're pretty much right in that range. So
exactly. And so if the lawyer that you are consulting with tells you that maybe you just want to keep it, really take that to heart, because again, this person has no financial gain by telling you to stay in your situation how you are. So when you take that into consideration, it usually increases the likelihood of them being genuine in their advice.
Right. I've also told people, perhaps you shouldn't go through the courts. Perhaps you should negotiate a consent order to figure out what the two of you think is fair. Here's where the numbers can lie. And then the two people can make a decision on their own to reduce the amount of support.
That's true. Now, here's where New York may throw you a wrinkle or a fly in your ointment. So in order to deviate and modify child support upwardly or downwardly from our Child Support Standards Act, which is the statute or the law that tells us what it should be, you must tell the other party in writing what they would have been entitled to. Yes, ma'am. Yes, ma'am. You must tell them what they would have been entitled to. And then you must give them a reason for the deviation.
Ooh,
so look, that's going to blow up a whole bunch of situations. Like, what?
You know, nobody's taking less than you tell them they're entitled to X. They're going to go, okay, I'll take X minus 5. Nope, not even $5
like
less.
So much. I'm about to take $1,000 less right here, right now. Okay, because no, that's most likely that's not going to happen. Now, I have been able to, because once again, I'm bigging myself up. I'm just so fly that I have been able to do that. But it's usually in situations where you're doing that as leverage for something else. Okay,
Yeah.
So you need to know that when you're modifying and you think, oh, I just got this sweet deal. We're gonna get this sweet deal. I'm gonna pay $1,200 a month, even though I'm supposed to be paying $1,800, and he or she is just gonna go for that. Look, even if they go for it, please realize that if they go for it and then get hip to the nonsense later on, poof goes your deviation. Mm-hmm.
I had no idea. That's a good tip. Just something to keep, an eye out on.
Mm-hmm. Yeah.
Fly in the ointment, as you say.
A fly in the ointment.
So New Jersey has a newish statute that says the probation department is no longer going to collect child support for children that turn 19. They just stopped collecting. And some people think mistakenly that means their child is emancipated and they no longer are required to pay support. So that's something that's a little bit different, and they are still required to pay support. The probation department is just not going to collect that money for them. And you're going to find yourself in a whole heap of trouble if you haven't been paying support and the other side comes in to enforce.
Yeah, see, so the state of New York, SCU, the support collection units, stopped collecting at age 21. So if you have arrears and your child is older than 21, even if you don't have any prospective child support obligation, the state is like, okay, so we know that they owe you $30,000, $50,000, $100,000. Good luck collecting that. Have fun. We're out.
Yep. New Jersey's bright line wear out, I think, is 23. Is it right? So they have, once they're 19, they say they're going to stop collections. You can actually petition and request. Really, it's not petition. You're really sending in a letter saying, here's the reasons why child support should continue to be going through probation. But I think their bright line rule is a 23. It might be 24. I'll have to double check on that.
Yeah, so you really have to be very concerned about what you're getting, what the documents say. You can't just assume that they mean something, based upon your limited understanding of the law.
Yeah. It also this is not really on modification, but there's also special needs children that may never actually be considered emancipated. And I've had circumstances where probation stops collecting. The court is saying you're no longer entitled to that because it's no longer called child support. I think it's called adult dependent support or something. I forget the actual term, but yeah, I mean, they're still entitled to it. You can still go to court and still get child support for an adult dependent, even though they would be considered, out of the probation collection agency.
And see, that is not happening. We covered that a little bit on another show, I think, some months ago. That is not happening in New York. Please understand, if you want child support in New York, it ends at 21, no matter whether your child has a developmental delay or any other type of disadvantage. You will not be getting child support for that child outside of an agreement to provide you with child support. So please realize that the laws are very, very sensitive to facts, and the laws in each state are extremely different. I wish for my clients who have children who will be dependent on them for the foreseeable future, even into adulthood, I wish that I could give them a different answer. But the law is not, at least the state of New York, does not consider itself to be on the side of morality, but just on the side of child support. Yeah, so.
John says he's paying too much.
Well, we are paying too much, John. We're paying too much because we're in an intact family. Listen, I'm thinking that it may be cheaper the other way around. I don't know. Yeah. Because these kids are expensive and they always want your stuff. Like, why do they always want your stuff? What is that?
Both of your daughters are about the same age, right? You and John's?
Yeah, John, we need to have a play date. But it might cost us too much.
It's probably going to cost.
I don't know where. John, are you going to answer this question? Are you going to answer this question? Oh my goodness!
I get way more than I give. So
this is a great answer. You know what? Rich got a fly wife. Like his wife is an OG right now with that answer.
Sounds really good, right?
So here's this question: if you lose your job, can you just automatically get a child support reduction because you lost your job and take it upon yourself to just stop paying child support?
No and no. No and hell no, actually. You cannot take it upon yourself to just stop paying child support at any time. You have to file an application with the court. The court does not encourage self-help. I've had cases where people are going to pay support into an account. That you can do that sometimes as long as there's really looks like there is going to be a reduction of support. But if you've lost your job and it's a temporary circumstance, the state of New Jersey is not going to just say, okay, we're going to review child support. They want to see that it's more than a temporary circumstance, and there's no bright line rule for that. It could be 6 months, it could be a year. Through COVID, we've really struggled with trying to work out child support orders and consent orders. I have a case where the children actually moved in with, the other parent full time, lived a full time with the other parent for 6 months. And the court still said that wasn't a permanent situation. So it really depends.
Yeah, John is saying, but I lost my job yesterday. Well, boo, you better go and start trying to get you another job, start pounding that pavement or something like that. People don't pound the pavement anymore. But yeah, that's not going to work out for you. It's not going to work out.
On the keyboard. No, and you have to really show in New Jersey that you've made a lot of efforts in order to get another job. So, how many resumes have you sent out? How many job applications have you completed? How many interviews have you gone on? Have you declined any interviews? Yes, sometimes the court is full of it.
He said the court is full of shit. That's what he said. My partner up here being good. John said sometimes the court is full of shit. And yeah, sometimes it is on both sides. I mean, on both sides. Look, it used to be, you see, in New York, we have now, and I'm saying now because it's still new in the law. Anything that is less than 30 years old is new, right? So in 2010, there was a huge change to our modification rules. And in New York, we now have a 3-year change of circumstances presumption. Okay. So the presumption is that you're entitled to a de novo review if you can show the change of circumstances financially every 3 years. If there's a 15% plus or minus change in income, you're entitled to a review, or then just a plain change of circumstances. So that leaves the door open to a lot of people being able to come in and say, oh, look, I need you to review, because what people used to try to do is say, oh, my child has gotten older, and so there's been an increase in expense as my child has gotten older. Yeah, the court said, yeah, okay, so it was foreseeable that your 7-year-old was going to turn 14, and yeah, no.
And by the way, the guidelines, at least in New Jersey, the way they've done the calculation is they've built that in, because they know if you're getting child support at a younger age, it increases over time as the kids get older. So if they're paying child support for the entire length of their life, that amount would have covered all of the various increases based on teenagers and everything. So if you set child support in New Jersey after the age of 14, you're going to get an increase of, what is it, 12 or 14%?
Yes,
these numbers
12
wrong
point
today.
something percent. Yeah, something like that.
12.5%. To factor in the fact that they have not been on child support since the beginning.
Not that that's enough money.
No.
These kids are expensive. These kids are expensive. If you are single and you don't have kids watching the show, just remember, these kids are expensive, so get your money in order.
I don't know when the last time they've done a review of the child support guidelines and what goes into it. I know they do some modifications a little bit based on, taxes and those kind of things, but like a real in-depth review, because all of the tech, all of the stuff that kids have nowadays, it costs a lot of money.
It sure does. Yeah, what is that? Okay, listen. Look, so this is what happened, John. Let me tell you what happened to my kid, right? Because our kids are around the same age, so they're all up here losing teeth trying to make a whole bunch of bank off of us. So what had happened was my daughter got a 20 for her first tooth. I think she got like 15 or 20 for her second tooth, whatever. Then she had nerve to take the teeth and lose them. So the tooth fairy didn't come. With the last 2 teeth, she lost them. So the tooth fairy didn't come, because how the tooth fairy going to give you something for nothing? Like, you're just going to tell the tooth fairy that you lost the tooth? Are they supposed to believe you? Come on. No. So I saved it on that. I was like, oh, you lost your tooth? Oh, man.
I love that. And for those of you who aren't seeing it on video, John is saying that the tooth fairy leaves his daughter $20 a tooth, and he's going broke. And my lovely co-host agrees.
The tooth fairy is a cheap ass at my house. Listen, how you gonna just not give me nothing for the tooth? I don't understand. I can't just be giving out money for okay, anyway.
At least she didn't get try to do some makeshift tooth with some clay. Put it under the
like a resin tooth, like get her a denture, a partial denture.
Better not say that too loud. I know she's in the room somewhere, so she's gonna have ideas for next time.
Right? She doesn't need any more ideas. But yeah, so that something that Steph said was really important. You're gonna have to make all of these proofs. So make sure, because in family court in Staten Island and just about everywhere else, so in New York, you're gonna have to come up with a job search history, a job search diary, or something, to prove that you have been trying to get these jobs. So make sure that as you're applying, you're keeping your stuff, you know what's going on, and then let's talk about the big elephant in the room. People who say that their businesses have been impacted. Ooh. Okay. Just remember this. First of all, when you start using accountants and everything, please make sure that your accountant understands that you may perpetually be brought back to court at some time. Don't allow your accountant to make up a business that you don't even run so that you can get a tax deduction. Okay, they are playing with your lives right there. They are playing with your life. They're playing with your money. And it's not cool that you can get, this $5,000 reduction on your taxes, but then later on, 2 years later, somebody's all up in your stuff about whether you really have a business or not.
Spending thousands and thousands of dollars on forensic accounting in order to figure and untie everything from your personal expenses to your business expenses. I also tell people all the time, stop paying your business expenses, your personal expenses out of your business account. Keep everything separate, because then when you're coming back to prove that your business has decreased, you're going to open huge Pandora's box of trying to sort through bank statements, what's personal, what's actually business related.
Yeah, so John is saying, in all seriousness, people need to entertain mediation before going to court. This starts with a good settlement agreement that requires mediation before court intervention. So I'm going to agree. I don't do mediation personally, but I am a trained mediator. And there really is a benefit to engaging in mediation. There's a benefit to engaging in collaborative law. I'm a collaboratively trained lawyer too. Because it just keeps the man out of your business. At the end of the day, the man, whoever the man is for you, right? And I'm talking about the judge, does not care about your individual case or your individual circumstances. What they care about is getting your case done so that they can move on to the next case. Now, there are some
Oh, no, go ahead. I didn't mean to cut you off.
There are some judges who really do care about you personally, about your well-being, but at the end of the day, you are just a family that they don't know. So if you think that you can mediate your case, by all means do so. Just make sure that you are mediating with somebody who also understands child support law, divorce law, whatever it is, so that you can be somewhat apprised, even though they're not representing you, of what the law is. That's the only place where mediation goes wrong, when people hire somebody and the person has absolutely no training whatsoever to do anything with regards to matrimonial law. I shouldn't be mediating those cases.
Yeah. So the reality is also with mediation, the court a lot of times with these kind of cases is going to order you to go to mediation anyway. So if you can short circuit that and start with mediation, then you can tell the court we tried mediation, it didn't work, and then hopefully they'll make a decision instead of sending you back to mediation. But I also recognize that one of the other flaws with mediation is not just the mediator itself of not having experience in family law, but it's having one or both parties not being candid about what their income and financial situation is. So if you go to mediation, there's no court that's ordering you to produce documents. So you're really on the honor system of what you're reporting as far as your tax returns, your income, your bank statements, to see if you're really getting what you need to get in order to calculate a fair amount of child support.
Yeah, that's absolutely true. And it's the same thing if you're doing this based upon, a negotiated agreement. You're not in mediation, but you're trying to just negotiate an agreement. There are no deadlines. There is nothing with any teeth on it, right? So, you are really on your own honor with getting this type of thing done.
Mm-hmm. I do want to backtrack a little bit, because you mentioned the 3-year rule with New York. So in 3 years, you get a de novo review of child support. That doesn't exist in New Jersey anymore. We had that at one point where if you were getting child support through probation, you could have your child support reviewed every 3 years, essentially as a matter of right. There's definitely no percentage that you can look at and say, if I have 15% reduction of income, I'm going to be entitled to reduction or review. Definitely not the case in New Jersey. They look at everything. They say you have to prove first that you have a change of circumstances that's permanent and significant before you could even be entitled to a review of child support, which is a hard burden sometimes, especially when you have somebody on the other end that's self-employed.
Yeah, it's a very difficult burden. And it's difficult also for the person who is receiving the child support, right? Because we focus a lot upon the person who's paying. But if the person who's receiving the child support is in a precarious financial position, they really don't have any real basis to definitely have a shoe-in win for modifications. And so, yeah, this is something that you have to really be very, very careful about. And also, remember that the court can impute income to people, okay? Imputing income, once again, Imputing income is the court acting as though you make a certain amount of money that you do not make based upon your history of making that amount of money or your ability to make that amount of money. And so that old adage of you can't get blood from a stone is not true in these circumstances. They can absolutely try to get blood from a stone, and if they don't get the blood from you or the stone, they will issue bench warrants. They will, and they being the state, will mess with your passport. They will cancel licenses that you may have, professional or otherwise. So if you like to go hunting, if you like to go fishing, they will cancel those licenses because you are in arrears on your support. And that's the same thing for New York and New Jersey. I mean, I think it's the same thing usually countrywide because
Probably.
there's some federal requirements for funding that states get, and so by virtue of getting this funding, all states essentially have to agree that they are not going to slack on enforcing child support obligations.
Right. They really want to have a uniform child support enforcement mechanism that's in place. So whatever state you're going to, they have pretty much the same mechanisms in order to ensure that somebody's paying child support, with the idea being that you have the ability to pay child support, you're just choosing not to pay. Because if you didn't have the ability to pay, you would come to court and you would tell the court, I don't have the ability to pay, and provide proof. That's not such an easy thing.
Right. And so that leads me to something else, right? So you are filing for a modification in court. Your modification, if it's granted, will not go back to the date that you lost your job or the date that you had this financial impact. It will go back to the date that you filed, because again, for the same reason, most of the states have said, yep, we're not going to retroactively modify child support. That is not what we're going to do. We are going to modify child support, if at all, from the date you file forward.
Right. There's only a few exceptions to that. In New Jersey, there's a statute that says if you provide written notice with a 45-day window and tell the person you're going to be applying for child support reduction or modification, here's the circumstances, I'm going to file a motion, and then you file the motion within that 45-day period, the court has the ability to do it retroactive to the date of your letter. I've only seen it happen like one time, because the courts kind of just say, no, we're not doing that. It's date of filing period. I even had judges say it's date of filing of the cross motion, when the cross motion is what asks for the affirmative relief of child support. So they really try to do that. And then emancipation is the other one. That's the pretty standard. If they're emancipated, you can go retroactive to the date of emancipation.
So I will tell you that with New York applications, I will give you an example. I had one case where this guy, I did not represent him. I would have given him better advice, but this guy did not file to emancipate his 25-year-old daughter until she was 25. And I just told everybody 21 is it in New York, unless you have an agreement to the contrary. So there are people who have agreements that allow for longer periods of time for child support. And it's generally 22 if the child is still in college, okay? And so the magistrate said, okay, so you've been paying the support for the additional 4 years? Okay, I guess you just gave your daughter a wonderful gift. Thank you. Have a nice day. And he was just like, what?
I'm assuming this was a direct pay.
This was direct pay. No,
Yeah.
Actually, no, it wasn't direct pay at the end. And I don't understand why his stuff was still being garnished. It was interesting. It was not direct pay at the end. I could not understand why he was one of those who I guess had fallen through the cracks somehow.
And by the way, just for anybody, when we say direct pay, we mean they're paying the person directly, a check for child support every month or every 2 weeks, as opposed to having the probation department in your area collect the payments either by garnishment or by payment directly to the probation department.
I remember why he was still SCU. It was because they had a younger daughter who had not yet aged. So SCU just continued to take the amount of child support they were told to take in the first place. So
that's an excellent point, because in New Jersey, it's to say that if the person is emancipated, the court will emancipate them in the probation record. So now you're paying child support for one child. the child support amount does not change. So you're now paying child support for the one child based on the original amount, unless you file an application for emancipation to set a new child support amount.
Right. And then people will say, oh, the court's full of shit again, like John said. But it's not. The court can't just be making up numbers. They don't know how much you make.
Right. They can't arbitrarily decide that because now there's one child emancipated, we're going to cut off a certain percentage or anything. You have an obligation to come to court and protect your rights. So I think in that circumstance, it wasn't necessarily as crazy as it sounded when you first were telling me. Because if you let it go that long and the other child was still on child support, I think it's pretty safe to say that child support was now for that other child because you never fixed it.
Never fixed it. Do not think that the court is going to do anything for you. That is not what they are there for. There are too many other people who have active cases going on. They are not monitoring whether your child is emancipated or not, unless there is no other child on the order.
Right. Whew, I think that's a really good takeaway. Make sure you're protecting your rights. The court is not modifying or reviewing your cases at all.
Oh, one last thing. What about this thing called COLA, cost of living adjustment? If your child support is going through New York State Support Collection Unit or Child Support Processing Center, you will be assessed a COLA review every 24 months. There will be a COLA review. And if you disagree with the COLA amount that is assessed, you can then request a review of the child support amount that you have been increased.
Yes, same in New Jersey. And it drives me insane because I have so many clients that say, I've had all these COLA increases, my job situation has never improved, and I'm actually making less money. I'm like, you get the notice. Literally, they give you a piece of paper, a notice, and they tell you, we're adjusting your child support by X percentage or whatever, it's going to increase to this amount. If you contest this amount, essentially just sign here and say you're contesting it.
That's it.
Never do it. Let the time expire. It's a free opportunity for you to have your support reviewed.
Yes, take the free opportunity for you to have your support reviewed. The worst thing that can happen is that your support doesn't get, modified. Mm-hmm. Worst thing that can happen. But if you're given a gift every few years, take the gift. Absolutely. And they might just say, no, we're not going to give you the COLA increase, but we're going to keep child support the same. That's still a win. And absolutely worth your time. And you don't need a lawyer to do that. You sure don't. You sure don't. All you have to do is pay attention to what is coming in your mail. What happens is that people get polarized. Like they get what do you call it? Oh my goodness. When you're frozen and you can't paralyzed. That's what it is. They get paralyzed when they see this mail coming in from the state or when they see this official document coming in. And that's normal. You got to move past it. In every circumstance having to do with your rights and the law, you must move past that initial state of shock, awe, and paralysis. And by the way, the negative connotation that everything that's coming in the envelope is going to be something that's bad news. Read it anyway. Yep. Brace yourself and read it anyway. We're all grown-ups. If you had a kid, you're a grown-up. Are you sure? You're grown. Let me say it that way. You had a child. You have a child support. You're grown. You have adult responsibilities. Yeah, start adulting, people. It up and open up that envelope. Start adulting. And on that note, we are going to bid you adieu until next week. Thank you for joining us, and we will see you next Thursday. Bye. Bye.